All right, we're back on the record on State versus Loyd. Mr. Loyd's present with his attorneys. The state attorney's office is present. I've been told that the jury has reached a verdict. Ladies and gentlemen, there will be no outburst in this courtroom, no reactions of any kind. You will remain silent throughout the verdict, regardless of what it is. Anyone who fails to obey that order will be removed from the courtroom by the deputies. All right, let's bring the jury in. State, recognize presence of the jury. Defense. All right, ladies and gentlemen, I understand you've reached a verdict. Is that correct? If you can hand that to the deputy, please. All right, Madam Clerk, if you'll publish the verdicts, please.
In the Circuit Court of the 9th Judicial Circuit of the State of Florida in and for Orange County, the State of Florida versus Markeith Loyd, case number 2016 CF 15738. Verdict as to count 1. We, the jury, find as follows as to count 1 of the charge. The defendant is guilty of first-degree murder. Verdict as to count 2. We, the jury, find as follows as to count 2 of the charge. The defendant is guilty of first-degree murder of unborn child. Verdict as to count 3. We, the jury, find as follows as to count 3 of the charge. The defendant is guilty of attempted first-degree murder. Special finding form regarding statute 775.087, Florida statute as to count 3. During the commission of the offense, did the defendant actually possess a firearm? Yes. During the commission of the offense, did the defendant personally discharge a firearm? Yes. During the commission of the offense, as a result of the discharge of the firearm, was great bodily harm caused to Ronna Stewart? Yes. Verdict as to count 4. We, the jury, find as follows as to count 4 of the charge. The defendant is guilty of attempted felony murder. Special finding form regarding statute 775.087, count 4. During the commission of the offense, did the defendant actually possess a firearm? Yes. During the commission of the offense, did the defendant personally discharge a firearm? Yes. Verdict as to count 5. We, the jury, find as follows as to count 5 of the charge. The defendant is guilty of attempted felony murder. Special finding form regarding statute 775.087 as to count 5. During the commission of the offense, did the defendant actually possess a firearm? Yes. During the commission of the offense, did the defendant personally discharge a firearm? Yes. So say we all, dated the 16th day of October 2019, signed by the foreperson.
Thank you. State, wish the jury polled? Defense? All right, ladies and gentlemen, if you'll answer yes or no to the question you're being asked.
Jury number 261, is this your true and correct verdict? Jury number 741, is this your true and correct verdict? Jury number 433, is this your true and correct verdict? Yes. Jury number 65, is this your true and correct verdict? Jury number 3146, is this your true and correct verdict? Jury number 1276, is this your true and correct verdict? Jury number 1425, is this your true and correct verdict? Jury number 1121, is this your true and correct verdict? Yes. Jury number 921, is this your true and correct verdict? Yes. Jury number 1066, is this your true and correct verdict? Jury number 1471, is this your true and correct verdict? Jury number 1560, is this your true and correct verdict? Thank you.
The jury is unanimous. All right, ladies and gentlemen, as I explained during jury selection, the conviction on first-degree murder means that we have to go forward into a penalty phase. What's going to happen now is we have to take a 3-day break for the penalty phase to be ready to go, so we will start the penalty phase on Monday. You will have to remain sequestered during that time, but we are providing you with some activities during that time, so you won't be locked in the hotel the entire time. We understand that this is an imposition on you all. We appreciate your patience and ask you once again to realize this, the seriousness of this case and the necessity for everyone to be well prepared for this. So I will not see you back in court until Monday. You will be returning to the hotel. If you have any questions or issues, by all means, let me know. Just write me a note. Anything that's special that's coming up in the next few days, let me know by sending me a note. The deputies will advise me and we'll do what we can to solve those issues, all right? So for tonight, you are discharged for tonight. You're free to go, but you remain jurors in this case. You remain sequestered. Yes, sir. Yes, just 1 second, please. Thanks. All right, let me clarify, because this is an experience none of you have ever been through, I understand that. The 2 alternates that were sent back to the hotel will be back joining you for the penalty phase of this case. They will sit with you to hear all of the evidence during the penalty phase. So you'll be having dinner with them and socializing with them and all of that. You all still are not supposed to discuss this case among yourselves until we're done with the penalty phase and there's a verdict there. You understand that, okay? The alternates, of course, are going to be told what the verdict was, because otherwise there would be no point to having a penalty phase. That's not a mystery, but why you reached that verdict, what your discussions were, can't talk about that. You understand that? So go back to talking about cars, sports, shopping, how much you want to go outside and be out of the hotel. We're planning an out-of-the-hotel function for you all, so we were not going to trap you in there every day, all right? Anything else? All right, have a good evening, folks. I will see you all Monday morning at 9 a.m. for the beginning of penalty phase. Again, let me know by note if there's anything that you need. All right, thanks. All right. Mr. Lennerman, the jury having returned a guilty verdict on the first-degree murder charges, at this time, the 3.202 notice from the defense is due to the state, as is the statements of the defendant that were blocked before, now need to be turned over to the state. The indication was that they were going to be turned over this evening, immediately after the verdict. Are you prepared to do that? Yes. Okay. Anything else that has to be turned over? State, have you made arrangements for your expert to examine Mr. Loyd?
Yes, ma'am, for 3 o'clock tomorrow.
Okay, and have arrangements been made for that expert to be deposed by the state, or by the defense, I'm sorry?
The expert is going to be here all day Friday on another matter, so we'll work out a convenient time. He'll be available.
All right, anything else that the court needs to address in terms of penalty phase at this point? All right. Mr. Loyd, a jury having found you guilty, at this time, the court adjudicates you guilty on all counts. I'm ordering that you be fingerprinted. Anything else? No? All right. Court's in recess.